Good afternoon, everybody. Welcome to the VBOC webinar. It's a pleasure to be here. I am Mauricio Vera. I'm the Assistant National Director of the Veteran Institute for Procurement. I want to welcome and thank you for joining us for today's webinar. And today we're going to go over SBA legislation and regulatory updates. So we got an absolutely fantastic panel of speakers for you. Today's webinar was developed to help veteran businesses accelerate growth in the federal marketplace. VIP, as you probably are aware, offers 4 different curriculums to give veteran-owned small businesses the tools they need to win government contracts. Participants receive hands-on, market-based instruction that helps establish best business practices for federal government contracting. And the program, the best part is that the program is offered at no cost. Programs that are offered are VIP Start, VIP Grow, VIP International, and our newest program that officially launched this week, and that's VIP Aerospace, which accelerates veteran small business success in the federal aerospace market. So for more information, please visit our website at nationalvip.org. Today's webinar is brought to you by the Veteran Institute for Procurement in partnership with the SBA and the Veterans Business Outreach Center. The slides and video recording from today's webinar will be made available on the VIP website at nationalvip.org, as well as emailed to you following this webinar. So kicking off today's presentation, it is my pleasure to welcome our speakers from the Small Business Administration. And I'm going to introduce John Klein, who is the Associate General Counsel for Procurement Law at the SBA and a longtime friend for many years. It's great to see you, John. Thanks for joining us.
Thanks, Mauricio. Good to see you as well. Again, my name is John Klein. I'm the Associate General Counsel for Procurement Law at SBA. And, you know, our office, the Office of Procurement Law, oversees and is the principal legal advisor for all of SBA's government contracting programs. With me today, I have 3 people. I have Mark Hagedorn, who's going to be talking about the 8A program. He's our principal legal advisor for the 8A program these days. Kate DePriest, who is the principal legal advisor for the WSB Women-Owned Small Business Program, and Alison Amann, our principal advisor for the HubZone program. So all 3, I thought, you know, certainly I could have done this myself, but these are the people that who do it daily, and they certainly are the ones that you should be talking to if you have any questions generally, right? And in the past year, this has been a really dynamic time for small businesses. In the last year and a half, we've made substantial revisions to the regulations governing the 8A program, the WSP program, and the HubZone program. You know, Mark will explain some of the more significant changes to the 8A rules, including changes to the Mentor Protege program, joint ventures, multiple award schedule contracts, release, and bona fide place of business. You know, Kate will explain that the new WSP certification program, the rules, the processing, what's happening with that. As a side, we can say, you know, as of yesterday, we had 1,906 WSPs were certified since October 12th when the program started. So that's pretty good. You know, almost 2,000 firms have been certified in the WSP program, are now eligible for contracts in that program. And Alison will talk about some of the HubZone changes that we believe will provide more clarity to the program, to the eligibility rules, and make it more appealing to procuring agencies to use the program. And she'll also mention a few of the flexibilities the SBA has implemented due to the COVID pandemic. And that's important to the COVID process. I'm sorry, to the HubZone process, because as you know, there are certain requirements about office attendance and all of that, and she'll explain some of that as well. And finally, I just wanted to mention in passing, I'm sure you've all heard about it, you know, as part of the NDA of 2021, SBA will be getting transferred to it, the certification process for both the SDVO and veteran-owned small businesses in the future. We have 2 years to do that, but we are already in talks with VA in the process and how best to do that to ensure that there's no disruption to the veteran community and to make sure that we do it properly and seamlessly. So I just want to give you that quick background before we start, and I'll hand over to Mark on the 8A side. Oh, and by the way, and there's a question and answer link here on the screen. If you have questions as we go through it, please put them in there and I'll try to answer them as we go. If we don't have any time for any, Mauricio will bring them out at the end, and we'll have some time to do some more questions and answers at the end. So without anything else, Mark, please. Thank you.
Thanks, John, and thanks for to the Chamber for the invitation to talk today. So with my time, I'm going to talk about two recent rulemakings regarding the 8A Business Development Program. The first is an interim final rule that SBA published on January 13th of 2021, which gives certain 8A firms the option to extend their participation in the 8A program, but also allows certain graduated 8A firms to be readmitted to the program for a period of time. The second relates to a comprehensive revision of the 8A program regulations, as well as several other program policy clarifications in the SBA Mentor Protege program and the size standards program. Unfortunately, with my 8 to 10 minutes today, I won't be able to cover all the highlights that are in my slide deck, but I provided hyperlinks to both rules that I'll be discussing today, in case you'd like to get some more detailed information. Next slide, please. I guess next slide as well. Great, so I'll start with the interim final rule. So if you track this extension authority, you'll recall that it actually first appeared in the NDAA for 2021. However, it was later added to the Consolidated Appropriations Act of 2021. The statutory language of both provisions authorizes a firm that was participating in the 8A program on or before September 9th of 2020 to extend its participation in the program for a period of 1 year from the date of the end of its program term. And that was irrespective of whether the firm previously elected to voluntarily suspend its program participation administratively in connection with the nationwide federal disaster declaration that was made on March 13th of 2020. There was no further clarifying language with respect to what on or before September 9th meant, but it was our understanding that Congress wanted to extend the program term because it believed that 8A firms had been adversely impacted by the pandemic and wanted to give 8A firms the opportunity to take full advantage of the program benefits. So in implementing this interim final rule, we determined that any firm that was participating in the program between March 13th of 2020 and September 9th of 2020 would be eligible to receive the program extension with several exceptions. And specifically firms that were terminated or early graduated or voluntarily withdrew in lieu of taking advantage of that voluntary suspension authority would not be eligible, even if they met the participation requirement that's set forth in the statute and the interim final rule. Last note on eligibility, firms that were admitted to the 8A program on or after September 10th of 2020 are unfortunately not eligible for the extension authority. Next slide, please. So I'm actually going to move into the Mentor Protege consolidation rule in the interest of time. This was published in mid-October and was effective on November 16th of 2020. As the title of the rule suggests, this rule actually began as an effort to combine SBA's two former Mentor Protege programs, the 8A Mentor Protege program and the All Small Mentor Protege program. However, as the rule was being drafted, we also took the opportunity to revisit certain program policies in the size standard program, as well as the Mentor Protege program, and then took a comprehensive look at the 8A program regulations as well. Next slide, please. So when SBA implemented the All Small Mentor Protege program in 2016, there were concerns from the 8A community that maybe eliminating the 8A Mentor Protege program might dilute the benefits available to the 8A firms. And so at that time, it made sense for us to keep a separate 8A Mentor Protege program in place. However, after several years, it became clear that we simply do not need to implement two separate Mentor Protege programs. The benefits of both programs were identical in that a protege and its mentor received the same exclusion from affiliation, and JVs formed under the Mentor Protege relationship were able to pursue any contract for which the protege firm individually qualified, again, irrespective of which program the mentor and protege sought. So from our perspective, it didn't make any sense to implement a redundant program at SBA, so we combined them into what is now the rebranded SBA Mentor Protege program. Next slide, please. So concerning joint ventures, we made 3 important changes that I'm going to highlight today. First, we eliminated SBA's role in reviewing and approving joint ventures formed to pursue competitive 8A procurements. We're hoping that this frees up much more time for our business opportunity specialists to provide actual business development assistance instead of focusing on the compliance piece that was associated with reviewing and approving joint venture agreements for 8A procurements. Plus, the size protest mechanism has, and we believe will continue to successfully police joint venture activities on competitive 8A contracts. But I'll note that SBA will continue to review and approve joint ventures that are formed to pursue sole source 8A contracts, because in this context, really only SBA and the contracting officer would ever actually see the joint venture agreement. Second, we revised the 3 and 2 rule, which you may recall precluded any particular joint venture from receiving more than 3 prime federal contract awards over a 2-year period starting on the date of the first award to the joint venture. We revised that to remove the 3 contract limit. So in this regard, 3 and 2 has essentially become unlimited in 2. In our view, the 2-year duration was still necessary to ensure that JVs for SBA program purposes are limited purpose entities. And then lastly, we added regulations governing how a joint venture qualifies for a small business prime contract that requires a security clearance. Under our regs, joint ventures are unpopulated, fictitious entities, so it doesn't really make sense from our standpoint for the JV to have its own separate clearance when the parties that are actually performing the work under the joint venture individually possess the required clearances. We also recognize that it might be appropriate in some contexts for the non-lead partner to the joint venture to provide the clearance on behalf of the joint venture under certain circumstances, such as where the secured work is ancillary to the primary purpose of the contract. But my last note on that, this is an ongoing topic of discussion with DCSA, NARA, and DOD, which all kind of share responsibility for clearances, issuing clearances on behalf of the government. So we hope to issue guidance between our 4 agencies very shortly on this. So next, we made some changes concerning small business order eligibility on multiple award contracts that are awarded on an unrestricted basis. In this context, contracts are awarded based on the offeror's capabilities and irrespective of small business size status, and there really is never any incentive to protest the size status of any particular awardee on an unrestricted multiple award contract. Under the prior regulations, if during contract performance, the CO set aside a discretionary order for small business participation, size status reverted back to the contract level certification, and any protest would be deemed untimely. So this ultimately allowed firms that no longer qualified as small to receive small business orders at a time when size was really relevant for the first time. So we thought this frustrated our program policies, and through this regulation, with the exception of the federal supply schedule contracts, a firm must generally qualify as small at the time of offer for the particular small business discretionary order in order to qualify for award under that unrestricted multiple award contract. Under the regs, a disappointed offeror may now also protest the order level certification that's made on an unrestricted multiple award contract. The same approach applies to small business multiple award contracts where the CO wants to further set aside an order for one of the socioeconomic categories that we have at SBA, like 8A, SDVO, HUBZone, or WASB. So in that context, a firm must qualify for that socioeconomic certification at the time of offer for that particular order in order to receive that award. Next slide, please. So as I mentioned earlier, I won't have time to run through all the changes to the 8A program regulations. So I'll focus on what we believe is probably the most significant change under this rule, and that is that for the first time, SBA regulations define what a follow-on requirement is for 8A program purposes. This is important in 3 different contexts in the 8A program. First, SBA will not accept a requirement for award through the 8A program where doing so would have an adverse impact on a small business that's performing the work outside of the 8A program. However, it follows that if a requirement is new or not a follow-on, there can be no adverse impact to any particular small business. Second, concerning entity participation in the 8A program, our regulations provide that a requirement that is being performed by a company owned by a tribe, Alaska Native Corporation, Native Hawaiian Organization, or Community Development Corporation, that that follow on to that requirement cannot be sole sourced to a sister company under that same tribe, Alaska Native Corporation, Native Hawaiian Organization, or Community Development Corporation, if that underlying requirement was awarded through the 8A program. And then lastly, SBA regulations in the FAR provide that once a contract is awarded through the 8A program, its follow-on or renewable acquisition must also be awarded through the 8A program unless the director of the 8A program agrees to release it. So the definition in SBA regs provides that SBA will consider changes in the requirement scope, magnitude, and end user in determining whether a contract is new or a follow-on requirement. Additionally, it notes that these factors are not dispositive, but they're to be used as guides so that federal agencies cannot circumvent the intent of adverse impact release or the sole source follow-on prohibition for entity-owned 8A firms. Specifically, I'll just highlight what has been kind of known as the general 25% rule with respect to changes in magnitude between an underlying requirement and what has been a purported new requirement. So if we were to apply that mechanically, that, for example, could be an opportunity for agencies to circumvent one of those three programmatic considerations that I just discussed. In addition, an agency now must notify SBA where work that was previously fulfilled through the 8A program will be reprocured outside of the 8A program, and that would include where such work is part of a requirement that the agency now considers to be new. And so especially in the wake of category management initiatives, we're seeing work leave the 8A program at an alarming rate, in part where the agency has combined the 8A work to another requirement to call it new. And so through this notification requirement, we're hoping that SBA now has a stronger voice and can get out in front of these issues before work actually leaves the 8A program. So I think I'll stop there and turn it over to Kate. And if we have time at the end, I'd be happy to go over some of the other things that I skipped in the slides. Thanks.
Yeah, I'm happy to start now. If Aaron, if you want to go to the start of the WASB slides. Okay. So like John said, I'm the attorney for the Women-Owned Small Business Program, which covers women-owned small businesses, WASBs, and economically disadvantaged women-owned small businesses, or ED-WASBs. Last year, we put out a final rule to implement some legislation from a few years ago, telling us that WASB needed to become a certification program. So it was previously self-certified, and with this final rule, it's now a certification program like 8A and like HubZone. So I'm going to talk about the final rule, certification, how firms can get certified, and what it means for procurements for firms. Okay, so the rule eliminated self-certification for firms that want to perform on WASB and ED-WASB set-aside and sole source contracts. And those are contracts that have WASB or ED-WASB eligible NICS codes. So the WASB program is unique in that only procurements with certain NICS codes can be set aside for firms participating in the program. So WASB eligible NICS codes represent industries where women are substantially underrepresented, and ED-WASB eligible NICS codes represent industries where women are underrepresented. Something to have on your radar is that we're actually reviewing the list of eligible NICS codes right now. That's also per Congress. They directed SBA to do a study every 5 years to look at those lists and make sure they still accurately represent underrepresentation in industry. So we're doing that now. The lists are currently the same, but sometime this year, we may be updating those. So just something to have in the back of your mind. So under the rule, to be eligible for a sole source, a firm has to be certified by SBA. And there's 3 paths to certification, and I'll go over those in more detail on the next slide, but just want to put them here. You can get certified through SBA, through another government entity, or a third-party certifier. I just want to note all the certifications are from SBA, regardless of the documentation you submit. It all goes to the director of the program, and he's actually the one who issues the letter saying you're certified. So to compete for a sole source, you have to be certified. To compete for a set-aside, you either have to be certified or have submitted a complete application that's pending certification. And that is its own slide at the end, because I think it's important enough to kind of focus on. So we can go ahead and move to the next slide now, and I'll get into that at the end. Okay, so the three ways I talked about, a firm can submit an application and supporting documentation to SBA. They can submit documentation that they were certified through 8A or through CVE, or they can submit documentation showing they were certified by one of our 4 approved third-party certifiers. So for 8A and CVE, you would have to show that your firm was 51% owned and controlled by one or more women, but the other eligibility requirements are met through those programs. So for example, in 8A, if a firm is 51% owned and controlled by one or more women, they already would have shown through their 8A certification that they meet our size requirements and that they meet our ED requirements, which I'll also talk about in another slide, because the rule aligned the 8A ED thresholds and the ED WASB thresholds. For CVE, again, their regs match ours for things like size and citizenship. They don't touch on whether or not a firm is owned and controlled by one or more women. So a firm would still need to show that, but submitting documentation of their CVE certification along with documentation of ownership would be sufficient. And again, the third-party certifiers, they would submit their letter showing that they've been certified. I also wanted to point out that-
we had a question about costs versus SBA versus third-party certifiers.
Yeah, thank you for reminding me. So getting certified through SBA, 8A or CVE, those are free options. The TPCs charge a fee, and I think you get other services associated with using a TPC, but that's for a fee. The other options are free. So
if a firm is currently CVE certified and they're also WSB owned, what should they do?
So they should go to certify.gov and submit their CVE letter or certificate, whatever they got from the VA showing that they were certified by CVE. And then also they would want to submit a passport or birth certificate or naturalization papers for their owners to demonstrate that they are 51% owned and controlled by one or more women who are US citizens. And if they wanted to be certified as an ED WASB, there's additional financial documents that they would need to submit because again, CVE doesn't look, there's no ED threshold. So for firms that previously participated in the program, these bullets are for you, basically just saying that if you had your documents in the repository, hopefully you have already moved them and already submitted an application for certification. The repository is no longer, and you would still need to get certified again if you wanted to work on set-asides or sole source contracts. You can still be self-certified for goaling purposes for agencies. I don't think that's as relevant to this audience. That's more for contracting officers to know that if a firm is self-certified, it can still count towards the WASB. But for everyone else's purposes, get certified. Okay, next slide. So the rule talks about how to apply, again, the different ways you can apply, and then how you stay certified. So we're on a 3-year cycle. First year, initial application, you submit full documentation, you get a letter from SBA. That letter is your anniversary. On your first and second anniversaries, you just attest that you still meet the eligibility requirements. So you go into certify.gov, answer 13 questions, say, yep, still meet all the requirements. By your third anniversary, you once again, that's a full document review. Off-cycle reporting would be if you are the subject of a status protest, a program exam, or if there's a material change to your eligibility, you would let SBA know, do a full document review, and then that would be your anniversary date. And then one other change that I think is helpful If your application's declined, you'll get a letter explaining what the deficit was in your application, so you can correct that, and after 90 days, reapply. Next slide. So I mentioned this 2 slides ago. The rule aligned the ED thresholds between ED WASB and 8A. And this is relevant because, as noted, if you are an 8A participant and you're owned and controlled by 1 or more women, you are automatically eligible to be an ED WASB. And that's because in this new rule, we brought the 8A ED thresholds in alignment with ED WASBs. So ED WASB's threshold was always $750,000 personal net worth for the individual claiming disadvantage. 8A's now matches that. And for both programs, funds in qualified retirement accounts are now backed out of the personal net worth calculation. Yep, okay, and that last bullet point we already talked about. Okay, you can go ahead. Next slide. So this was the point I wanted to focus on that I talked about in the first slide. This is pretty technical, but basically this is addressing the fact that our regs reference registration in SAM. So previously, SAM, or well, currently, but hopefully not forever, firms can self-certify that they're a WASB in SAM. Now that we're a certification program, we want SAM to look the way it does for 8A and HubZone applicants. So only SBA can check that box in SAM, showing that a firm is a HubZone or an 8A participant. We want the same for WASB now that firms need to be certified. GSA owns and controls SAM, SBA does not, and updates to SAM are on a schedule that we have no control over. So SAM has not yet been updated to reflect that SBA now certifies WASBs. The stopgap that we came up with is for firms to be able to show in DSBS, the Dynamic Small Business Search, that they have a pending application for certification that's been completed. So if you've submitted an application to SBA and you're just awaiting a decision, you're eligible to compete for set-asides. If a firm is the apparent successful offeror, the CO would go into DSBS, check, see if they're either certified or have a pending certification. They would then, if the firm certified, great, no problem. If they have a pending certification, the CO reaches out to SBA, says that the apparent successful offeror, please expedite review. Per our regs, SBA has 15 days to do that, but I think it would be done more quickly because we wouldn't want any firms to miss out on opportunities because their application's awaiting review. So assuming that they are eligible, SBA would issue them a letter, tell the CO, yep, they're eligible, and they could move forward. And again, this is until hopefully at some point we get a SAM update and that will reflect SBA checking that they're certified as a WASB or ED. So that is all I have. I don't know if we should go into alleys and do questions at the end. Okay.
So I'll keep this pretty brief, but I'm going to go over the recent updates to the HubZone program. The HubZone regulations underwent a comprehensive review by a final rule published in November of 2019, and this was the first comprehensive review we did of these regulations since the program was implemented more than 20 years ago. So we made a lot of updates to reflect current policies, and we also implemented a number of changes that came through a statutory change in the 2018 National Defense Authorization Act. So these slides kind of highlight the big changes, and if there's questions, again, we'll try to get to them as we can, or if you have questions, you can send them afterwards. So first of all, as a result of the 2018 NDAA, the HubZone maps were frozen they're currently frozen through the end of this year. They're ultimately going to be frozen until we have data from the 2020 census to be able to update them. And once the maps are updated, they'll be updated on a 5-year cycle. So that's brand new to the map updates. They used to be updated every year, sometimes multiple times a year. This will create some stability to the program.
Now, Alison, did you say that it will be extended? Have we said that officially yet?
There's no official word on the extension to that current end of the freeze. The end of the freeze, as I mentioned, is December 31st of this year. But keep an eye out for updates on that because it's likely to happen. The new rule also, instead of 3-year recertification, which is how the HubZone program always worked, under this new rule, we're now requiring annual recertification for all HubZone participants. And in order to recertify, a firm must meet the HubZone requirements on the anniversary of its initial certification date. And what recertification means is that that firm, once it recertifies, is eligible for all HubZone contracts for the following year. So in the past, firms had to be eligible at the time of both offer and award. And under this new rule, they have to recertify, be eligible at the time that they recertify, but then they don't have to prove their eligibility at the time of offer and award any longer. They just have to be certified at the time of offer for a HubZone contract. And then if there's a protest, a HubZone protest, challenging that firm's HubZone status, we would look back to their most recent recertification and confirm that they were in fact eligible at that point in time. So that should speed up protest processing, hopefully, and it should, we're hoping, lead to fewer protests. I'm going to skip this last bullet because Mark went over this. We can go to the next slide. Another big change is we finally defined clearly what attempt to maintain is. So for the HubZone program, by statute, for HubZone participants, while performing HubZone contracts, must, instead of having 35% of their employees residing in a HubZone, attempt to maintain compliance with that percentage. And we have, by regulation, defined that to mean 20%, having 20% of your employees residing in a HubZone. So firms that are recertifying under these new regulations that are performing a HubZone contract at the time of their recertification will need to demonstrate that they're attempting to maintain compliance with the HubZone residency requirement, which will mean they'll have to show that they have at least 20% of their employees residing in a HubZone.
So that's really key. So in that next year, you'll be eligible again only if you have 20%, and you can get additional contracts even when you have 20%, not 35. So that's a big change, and it should help firms stay eligible for the program.
Exactly. Yeah, that was the big purpose of these change. A lot of these changes was to make it easier to get into the program, but then especially to make it easier to stay in the program, because that was a big complaint we were seeing over the years. And related to that point, the second bullet, where we implemented a new provision, which is being referred to as the legacy HubZone employee rule or legacy employee rule. And under this rule, a firm that has an employee who resides in a HubZone at the time the firm is certified or at the time of a recertification, if that employee continues to reside in a HubZone for 180 days after that either certification or recertification date, and that person remains an employee of the HubZone firm, they can continue to be counted as a HubZone employee for future recertifications, even if they move out of a HubZone or if the area where they reside loses its HubZone designation. So this is a way to retain employees that may, have an improved situation and be able to move out of a HubZone. And it doesn't force firms to hire new people they don't necessarily need just because certain employees that they don't want to get rid of have moved.
Or if the HubZone area has changed to a non-HubZone area, we don't want to penalize the firms for nothing that they did wrong.
Exactly, right. Another big change from this reg is what we're calling the long-term investment provision. And this allows a firm which has its principal office in a HubZone to, if it has entered into a long-term lease or purchased a building in that HubZone area, and that building or location remains the firm's principal office, they can continue to be treated as meeting the principal office requirement for up to 10 years, even if the area where the principal office is located loses its hub zone designation. And this is meant to reward firms for making long-term investments in hub zones. So this is a brand new change. We're still kind of working out the kinks, but something to note is that redesignated areas are excluded from this provision. So a firm that has its principal office in a redesignated area would not be eligible for this 10-year treatment. But principal office in a qualified census tract or a qualified non-metro county exempt, for example, would be allowed to take advantage of this. And then the last bullet on this page, I know we're way over our time, I apologize. But the last bullet here just notes that we are processing applications within 60 days of receipt of a complete package now. And two notes I want to make with respect to the COVID flexibilities. Firms that apply to the Hub Zone program that indicate they're looking to go after a solicitation related to a COVID relief effort will have their Hub Zone application expedited. And then secondly, firms which can have their employees teleworking due to the social distancing requirements resulting from COVID-19 can treat individuals who would otherwise be working at the principal office but are teleworking due to COVID. You can essentially treat them as principal office employees as long as the firm submits a statement saying these people would be working at the principal office. If not for COVID, they will return to the principal office once these social distancing requirements are lifted. And those flexibilities are in place until the end of the fiscal year, until September 30th. And then the very last slide I have here, for that last slide, is under a different direct final rule that we issued in 2019, also resulting from the 2018 NDAA, authorized a new type of hub zone referred to as a governor designated covered area. And this essentially allows areas that aren't otherwise hub zones, but are essentially on the brink of being hub zones. And this applies to rural areas in particular. It allows state governors to submit a petition to SBA saying, I have these areas that aren't hub zones, that are close to being hub zones. Basically, they're rural areas, they have high unemployment. They can submit a petition to SBA on an annual basis. SBA will review it and can add additional hub zones in rural areas under this authority. So that's brand new, and we're hoping this will expand the program even further.
Thanks, Alison. Okay, Mauricio, I think that's all we have. So back to you.
Thank you, John. And thank you, Mark, Kate, Alison, lots of really important information. Thank you for taking the time. And if we're out of time for questions, but if anyone has questions, they can send them to us and we'll forward them to you. Thanks for taking the time, John. Good to see you.
Thank you.
Next, we have Bloomberg Government is joining us. Apologies, we got started with you a little bit late, but you have lots of very important information. I'm going to introduce Robert Levinson, Senior Defense Analyst for Bloomberg Government, and he's going to introduce his colleague as well. Robert, it's all yours.
Okay, thank you, Mauricio. Yeah, I'm Rob Levinson. I'm Senior Defense Analyst at Bloomberg Government. My colleague Chris Cornillie will be joining me. We're going to try and go through our slides rather quickly here since we're short on time, and we'll see if we have questions for Q&A. So I'm going to go through the first few, and then Chris will sort of close us out. So first of all, we're going to talk about OTA authorities. That's other transaction authority or other transaction agreements. These are things that have been exploding in the federal government as a way of sort of bypassing a lot of rules and regulations. We've seen, as you can see from the data there, go from about $1 billion in 2015 to $17.8 billion in contracts using OTA in fiscal 2020. Most of that is DoD. A lot of this goes through consortia. We'll explain what that means. And we're going to talk a lot. This has been used very heavily by Health and Human Services and DoD in the past fiscal 2020, really to combat the COVID pandemic. Let's go to the next slide, please. Okay, so as I said, other transaction agreements, it's a sort of this thing that was set up for NASA back in 1957 when Sputnik went up. It was a way of speeding up the contracting process. Basically, it waives a lot of rules of the FAR and the DFAR and allows mostly for research and development, prototype development, and allows the government to move very fast with unique requirements out to the government, out to contractors, and they can award. There's a few different kinds of OTAs. There's the ones that go through consortia, which are groups of like-minded companies sort of centered around a particular technology area. There's some that are awarded directly to contractors. There's also these things called commercial solutions openings. And then sometimes there are follow-on production contracts. A big one recently was Microsoft. They developed this headset for the Army and under an OTA, and then they got a huge follow-on production contract of $22 billion to actually produce these things for the Army. Let's go on to the next slide, please. Okay, so as I said before at the beginning, agencies have kind of spent a record on OTAs in fiscal 2020. And a lot of that, of course, has been driven by the COVID vaccine, a lot of the vaccine development and other countermeasures to deal with COVID. The government used OTA. It was very flexible, and we really see HHS pop up on the screen using them in 2020. They hadn't used it much before, but it became very useful to do that. And again, a lot of that Pentagon spend is, in fact, for COVID-related stuff, as well as other traditional sorts of technology areas. Let me go to the next slide, please. So here we sort of broke it down. Actually, Chris did most of the breakdown here on showing what was sort of COVID-related versus traditional DoD, and you can see in 2020, you know, how much of this was COVID-related. Going for a lot of that went through the medical, chemical, biological, radiological, nuclear consortium, and to companies like AstraZeneca, Johnson & Johnson's, Q Inc., Regeneron. This is for medical countermeasures of one form or another. And with that, I'm going to turn it over to Chris. So Chris, take it away.
Thanks, Rob. So this slide is just breaking down the previous slide by agency bureau. So taking one step closer of a look at who is spending money via other transaction authority. The two biggest funding agencies within the federal government are the Army Office of Acquisition, Logistics, and Technology. AL&T was responsible for most of the COVID-related OTA spending in fiscal 2020, so it's not surprising that they are at the very top of the list, as well as Army Materiel Command. U.S. Space Force, the newest DoD agency, is very near the top of the list. Much of what they do is commercial space flight and contracts to provide more competition in that market. Think about companies like United Launch Alliance, which is a joint venture between Boeing and Lockheed, and Jeff Bezos's Blue Origin. For the first time, we saw OTA spending by BARDA, which is the Biomedical Advanced Research and Development Authority. It's basically DARPA within HHS, kind of like the biomedical research SWAT team. And just below that is DARPA itself. The only other civilian agency that spends a lot of money through OTAs is the Transportation Security Administration, and a lot of those agreements are really related to airport security and their projects collaboratively between TSA and state and local airports. We can move on to the next slide. So we talked a little bit about the consortium model of OTA funding, and about 57%, a little bit more than half of all OTA spending flows through consortia, which are like-minded groups of companies, large and small businesses, universities, research institutions, FFRDCs. The two largest are the Medical CBRN Defense Consortium that was responsible for speeding a lot of the R&D that was used to fund vaccine development through Operation Warp Speed. The Defense Ordnance Technology Consortium, that's a lot of cutting edge research on guided munitions and missiles and hypersonics. But a lot of these consortia are related to high-end defense technologies, things like artificial intelligence, advanced microprocessing applications, and the like. If we can move on to the next slide, please. I'll just spend 5 seconds on this page. We provided for viewers today a list of the consortia that we're tracking, close to 36 of them at this point, and all of these will be linked to the consortia page. We highly recommend that you do a little bit of research and see if there are any worth joining. Typically, barriers to entry are very low. Next slide, please. So we mentioned that about just over half of OTA spending flows through consortia. About 43% gets awarded directly to companies or via teams through contracts like broad agency announcements for R&D. Some of the top recipients of OTA funding are AstraZeneca and Johnson & Johnson through Operation Warp Speed, but they weren't the only ones. Traditional defense and aerospace contractors like Lockheed, Northrop, Raytheon, United Launch Alliance also feature heavily on this list. One thing that we wanted to call your attention to is there are very few small businesses that are receiving OTA contracts as the primes. So one of the requirements of awarding an OTA contract is that there must be team members participating to a significant extent that are either small businesses or non-traditional defense suppliers, which means startups and any company that hasn't won defense contracts in the last year. So when you think about these types of contract awards, all of these involve some participation by small or non-traditional businesses, but only very rarely are these contracts being awarded directly to small businesses or small business-led teams. In 2020, only about 6% of OTA obligations flowed to small business-led teams. And we think that that's something that, that the Defense Department and other agencies using OTA need to take a look at. Next slide, please. On this slide, we shared a look forward. This is historical spending on other transaction authority at the DoD by quarter. In blue, you can see spending on traditional defense hardware and technologies. And in black, there's spending on COVID-related countermeasures. So that's vaccines, rapid testing kits, PPE, pharmaceuticals, et cetera. We think that by the end of fiscal 2021, that wraps up at the end of September, we'll see about $10 billion on traditional defense hardware, in addition to at least about $3 billion of COVID-related OTAs. So that would bring the total to 13 or so billion dollars on OTAs in fiscal 2021, which would be slightly less than we saw in fiscal 2020. However, given the unprecedented nature of the COVID-19 pandemic, that's probably not surprising. One thing to keep in mind here is that the Biden administration has put research and development at the forefront of his 2022 budget request. So investments in combating climate change, in maintaining technological superiority, and in modernizing the U.S. technological base. So OTAs offer a really compelling way for federal agencies to quickly allocate R&D funding to critical imperatives. So I wouldn't be surprised to see more agencies start to use OTA if they're granted permanent authority by Congress. I would expect to see the Defense Department and Departments of Homeland Security and Health and Human Services to broaden the portfolio of things that they're using OTA authority on. But overall, this is a very promising market to be involved in. And yeah, with that, I think we've got about 9 minutes or so. Happy to take questions or comments from the audience.
We have any questions?
Turn things back over to Mauricio.
Thank you, Chris. Thank you, Rob. Anyone have questions for our friends from Bloomberg? Let me see if I don't think we have any at this point. And I think most of what was in the chat has been answered. Okay, so with that, let me thank our speakers. There's lots of great information from Bloomberg, as always. Lots of good information on OTAs. It's interesting. It's an interesting topic and something that sounds like it's becoming more and more a factor. So, thanks again to Rob and Chris, and to all of our speakers, also our SBA speakers, for great presentations. And thank you to our participants for attending the VIP VBOC webinar, and to the SBA for making this webinar possible. I'd just like to ask everyone if you would take a moment to complete a very short survey that will be sent to you immediately following this program. Your feedback is very important to us. Thank you to everyone again. We wish everyone continued success in 2021 and hope to see you at our next VIP VBOC webinar. Thanks again. Take care, and you can have your 7 minutes back and enjoy the rest of your day. Bye, everybody.
Thanks, everyone.
Thank you.
Bye.
Bye.